He said it to my face, under oath, in my courtroom, with the composure of a man who had said it before and watched it work. Your Honor, I am the victim in this room. And I want you to understand something about that moment before I tell you what came next. I was not surprised. Not because I am incapable of being surprised. 39 years on the bench and I have been surprised more than once. I was not surprised because I had requested the footage before he walked through that door. I had read the filing the night before, I had recognized the architecture of it, and I had made one phone call that morning to confirm that the footage existed and was available for the session. He had spent weeks building a version of this case. He had filed a complaint naming the security officer who had done her job as the person who had committed the harm. He had prepared his account. He had shaped it carefully, given it language, given it sequence, given it the framework of a man who believed the room was going to recognize something about him that would make the evidence secondary. He walked into my courtroom, and he had no idea I was already holding 37 seconds that made his version impossible. My name is Marcus Reed. I spent 28 years on the circuit court bench in Atlanta, Georgia, and I have watched a great many people walk into that room with a story. Subscribe to this channel and hit the bell, because what I bring here is exactly what I brought to that bench. What I saw, from the seat that decided without ceremony. Tell me in the comments, what is the hardest part of watching someone flip a narrative and almost make it work? The truth is this: a courtroom is not a place where the better story wins. He looked directly at me, and I mean directly in the way that people look at a judge when they believe the judge is about to do them a favor, and he said, "Your Honor, I am the victim in this room." Those were his exact words. I wrote them down. I'm going to tell you what happened in the 30 seconds after he said them. But before I get there, I need you to understand what kind of morning it was when I walked into that courtroom. Because the 30 seconds only mean what they mean if you understand what was in that room before them. I had read the docket the evening prior. That is my practice. I do not walk into a proceeding cold. I read what was filed. I read the counterfiling. I read the complaint in the language it was written in. And when a complaint is written in a particular language, a very specific language, one I have encountered before, a language about natural persons and sovereign standing and the unlawful authority of private security over a free man, I know what I am going to be looking at when I walk through that door. Not who. I did not know who yet, but I knew the architecture. I have seen this architecture before. I know where the weight-bearing walls are. He arrived before his case was called. This I observed from the bench while an earlier matter was still being resolved. He came in, found the defendant's table, and adjusted the chair. Not dramatically, just moved it a few degrees, angled it slightly toward the center of the room rather than toward the bench. A small thing, the kind of thing that in isolation means nothing. I have spent 39 years in rooms where small things mean everything, and I noted it, and I set it aside, and I continued with the prior matter. What I want you to understand about that chair is not that it was suspicious. It was not suspicious. What it was specific. It was the action of a man who had already decided how this room was going to be arranged around him. Not around the proceeding, around him. He had walked into a courtroom, a room with a particular architecture of authority, with a bench and a seal and a flag and two tables facing the same direction for a reason. And the first thing he did was adjust his relationship to the center of it. I noticed. I filed it. The security officer, the plaintiff in this matter, arrived at the other table with her incident report and nothing else. She sat down and she waited. She did not look around the room. She did not look at the defendant. She looked at the report in front of her, briefly, the way someone looks at a thing they have already memorized to confirm it is still there. I have watched hundreds of people sit at that table. I know the difference between someone who has prepared a performance and someone who has simply come to say what happened. She had come to say what happened. I want to name something I observed before a single word of testimony was entered. The defendant's complaint, the document he had filed, in his own hand, in his own language, described the security officer as having committed an assault against his person. It used that word, assault, and it described him with specificity and conviction as the injured party in a situation that had begun when she had failed to recognize his standing as a sovereign individual and had therefore approached him without lawful authority. I have prosecuted cases for 11 years and presided over them for 28. I know what a document looks like when it is constructed. I do not mean fabricated in every particular, I mean built, the way a thing is built when the builder starts with the conclusion and works backward to the language that supports it. This document was built, every word chosen, every phrase calibrated, not for accuracy, for framework. And what I understood, before the session was called to order, was that I was looking at a structure, not just an argument, a structure, built specifically to make the person sitting at the other table defend the act of doing her job. That is what I was about to dismantle. I did not know yet exactly how. I had the footage. I had requested the footage before the session began and confirmed it was available. I knew where the wall was. I did not know yet how long the defendant would need before he understood it was no longer standing. The defendant had chosen to represent himself. This is not unusual in cases of this kind. The ideology specifically holds that the system's attorneys are part of the system and therefore compromised by it. I have watched people argue their own cases before me with genuine skill. I have watched people argue their own cases before me with no skill at all, but with such sincerity that the sincerity became its own kind of argument. And I have watched people argue their own cases before me with something that was neither skill nor sincerity, but certainty. The certainty of a man who believes the room is going to recognize something about him that will make the evidence secondary. This defendant had certainty. He stood when I asked him to present his complaint. He stood with his hands loose at his sides, not nervous, not formal, loose, the way someone stands when they believe the posture of authority does not apply to them, and they are demonstrating that belief with their body. He said his name. He said his name in a particular way, with a pause before it, a brief pause, the pause of someone who has read about the legal significance of how a name is stated in a proceeding. I know this pause. I have heard it before. He then proceeded to describe what had occurred. He was precise. I will give him that. He had a sequence. He had language for each moment in the sequence. And he had constructed the sequence so that every action he described himself taking was a response to something she had done first. She had approached him. She had failed to identify lawful authority. She had made contact with his person without consent. He had, in his words, defended his natural right to his own body. He delivered this with the composure of someone who has rehearsed it. Not for this room. In this room, he was performing it. He had rehearsed it in the rooms before this one, wherever the version had been given before a hearing happened, before someone with actual authority over the proceeding was present to ask the next question. I listened to the complete account. I do this always. I do this because the account, the full account, given all the space it needs to become what it actually is, contains everything I need, not just what is said, what is chosen, what is emphasized, what is arranged around the center to make the center look like something it is not. I then asked the security officer to speak. She stood. She adjusted nothing. She looked at me, not at the defendant, not at the gallery, at me, and she said, I responded to a report of a man refusing to leave the premises. I identified myself by name and by the company I represent. I asked him to follow me to the exit. He told me I had no authority over him. I placed my hand on his arm to guide him. He pulled away and then struck me in the chest with his open hand. I restrained him until my colleague arrived. That is what happened. She sat down. 11 sentences. I counted them later. 11 sentences, no qualifications, no framework, no language designed to put something in the center of something else. Just the sequence, in the order it occurred, as she had lived it. The defendant was on his feet before I indicated he could approach cross-examination. I let him stand. I waited until he understood that standing had not produced the result he expected, and then I indicated he could proceed. What followed was 22 minutes of cross-examination that I can only describe as a man attempting to find a door in a wall that had no door. He asked her whether she had documentation of her authority. She provided it. The company identification, the state certification, the incident report filed within the hour of the event. He asked her whether she understood the difference between a statutory person and a natural person. She looked at him with a patience that I found, in the specific way I find certain things in these proceedings, admirable. And she said she did not believe that distinction was relevant to the question of whether he had struck her. He asked her whether she had felt threatened. She said she had. He asked her by what? She said, by being struck in the chest. I watched him. I watched the sequence of questions, and I watched the space between them, where a different kind of calculation was happening than the one being performed on the surface. He was not confused, he was searching. He had a map, and the room was not matching the map, and he was looking for the place where the room would start to match. He had asked these questions, or versions of them, in smaller rooms, and the smaller rooms had not had someone like her in them, someone who simply answered what was asked and offered nothing else, nothing that could be taken and reshaped, nothing with a seam that could be pulled. He was running out of map. After 22 minutes, I asked whether the defense had concluded its examination. He said he had one more question. I allowed it. The question was, do you believe this court has jurisdiction over a matter involving a sovereign individual? She said, I believe this court has jurisdiction over a man who struck me. He sat down. I asked both parties to remain seated. I said I had requested an item of evidence at the outset of the proceedings that I would now like to enter into the record. The bailiff brought the footage on the system we use for exhibits. It is a screen at the front of the room, mounted to the left of the bench. I have watched many things on that screen. I have watched security footage before. I have watched footage that confirmed what I already suspected, and footage that surprised me, and footage that was ambiguous in ways that required careful interpretation. This footage was not ambiguous. 37 seconds. The defendant approaching from the left of the frame, the security officer visible from slightly behind and to the right. Her body language, the body language of someone performing a routine task, the approach measured and professional, one hand raised in a gesture of direction rather than constraint. The defendant stopping, the defendant speaking. You could not hear the words, but the posture was unmistakable. The posture of a man explaining something to someone he believes does not have the standing to be explained to. The security officer placing her hand on his arm, and then the defendant's right hand open across her chest. 37 seconds. I let it play once. Then I let it sit for a moment. I did not look at the defendant immediately. I looked at the screen after the footage had ended, the way I look at a document after I have finished reading it. The way you look at something when you want the room to understand you have registered every detail of what was just shown. Then I looked at him. He was looking at the screen. Not at me. At the screen. At the place where the footage had been, as if looking at it long enough might produce a different version of what it had shown. I know that look. I have seen that look from that chair more times than I can number, and every time I see it, it is the same. It is the look of a version of events meeting the record, and the version losing. I asked him if he had anything he wished to add to his account in light of the exhibit. He said, "That footage does not accurately represent what occurred." I said, "The exhibit is entered into the record." I said it calmly, because I am always calm, and because calm in that moment is not a failure of feeling. It is the opposite. It is what 39 years of watching that specific look from that specific chair produces. The absolute, unshakable certainty that the room does not need my emotion. It has the footage. He lied to me. I want to be clear about that because sometimes in legal proceedings the language becomes careful. An inconsistency in the account, a discrepancy between the testimony and the exhibit. I am not going to do that here. He sat in that chair and told me something he knew was not true. He constructed a document designed to place a woman who had done her job in the position of defending herself against a charge of assault. He filed that document. He stood in my courtroom and delivered a version of events that 37 seconds of footage made impossible. And then, when shown the footage, he told me it did not accurately represent what occurred. That is what happened. That is the whole of it. The ruling was not complicated. I ruled that the defendant's complaint was without merit, that the incident report filed by the security officer was consistent with the exhibit entered into the record, and that the defendant had committed an assault as defined by the relevant statute. I noted for the record that the defendant had made representations to this court that were demonstrably inconsistent with the evidence. I noted it not because it was legally necessary to the ruling. I noted it because it needed to be on the record, because a woman had been filed against, had been named in a document as the aggressor in a situation where the footage showed her doing her job, and the record needed to say, clearly and permanently, that what that document claimed was false. I have been in this room for a long time. I have delivered rulings that were difficult, where the evidence pointed in a direction I found painful, where what was right and what I hoped for were not the same thing. This ruling was not difficult. but the ease of it did not make the weight of it light. Here is what I want to say about that security officer. She came to that proceeding with 11 sentences and an incident report. She did not bring a lawyer. She did not bring supplemental materials or character witnesses or documentation designed to make her appear more credible than the record already made her. She brought the record, and she trusted it. And I want to say directly, the way that I believe these things deserve to be said directly, that trusting the record is not a small act. I have watched people come into that room having been named as aggressors when they were not, having had a document filed against them that reconstructed their actions in a language that was designed to make accountability impossible. And I have watched those people doubt the record, doubt themselves, spend years in the anxiety of wondering whether the constructed version will win. She did not doubt it. She came in, she told 11 sentences of it, she answered what she was asked, and she trusted the 37 seconds. The dream released. I have thought about this case in those terms. The dream released. Because there is something this ruling could not give back. It could not give back the weeks between the filing and the proceeding. It could not give back what it cost her to be named in a document that called her an aggressor. It could not return whatever confidence the filing had taken from her in those weeks. Confidence in the straightforward truth of what she had witnessed with her own body, done with her own hands, in the performance of her own job. Some of that stays in the weeks it was taken from. The ruling does not reach back and retrieve it. What the ruling does is say, permanently for the record, this is what happened. Not his version, not the constructed version. This. What the footage shows and what her 11 sentences described. That is not everything. But it is the thing this room can do, and this room did it. He walked into this room with a story. I had 37 seconds of footage. The story did not survive the footage. That is what this room is for. I have been asked, over 39 years, many times and in many ways, what a courtroom is. I have heard the beautiful answers, that it is the place where the truth is established, where justice is pursued, where the law is made real in the lives of particular people. I believe some version of all of those things. But what I know from the seat I occupied for 28 years and from the 11 years before that deciding what came to that seat at all, is something more specific. A courtroom is a place where the story meets the record. Not the better story, not the more confident story, not the story that has been rehearsed in more rooms before this one. The story meets the record, and the record does not negotiate. He had spent time with his story. He had shaped it carefully. He had given it language and sequence and a framework designed to make the room understand the situation the way he needed it to be understood. He had brought it into my room, and he had delivered it with the composure of a man who had delivered it before and watched it work. And I had 37 seconds that someone's security camera had been running without his knowledge, and that I had requested before he walked through the door. I want to ask you something, not about this case, about what this case brought up for you. Because what I watched this defendant do, and I want to be precise because precision is the only honest tool, was not unusual in its basic shape. The shape of it, the building of a structure designed to make the person harmed defend the act of existing, of doing a job, of being in a place where someone had decided the rules did not extend to them. I have watched that shape in many forms, in many rooms. What is the hardest part of watching it? Not when it succeeds, when it almost succeeds, when the record is close but not quite there, when the footage is 37 seconds long and some cases do not have 37 seconds of footage, when the person at the other table has 11 sentences, and not everyone has 11 sentences that are that clear and that steady. Write it in the comments. What is the hardest part of watching someone flip a narrative, claim the harm they caused, and watching the room almost believe it? Name it honestly. I read every one. If what you heard today is the kind of accounting you have been waiting for someone to do out loud, the kind that does not perform neutrality when the record has made neutrality dishonest, then subscribe to this channel. Hit the bell. What I bring here is the same thing I brought to that bench for 39 years. What I saw, from the seat that saw it, without the ceremony that seat required and that I no longer have to perform. I am glad you were in this room with me today. That security officer trusted 37 seconds of footage and 11 sentences of truth. She was right to. The record said so. This courtroom said so. I said so. And now you know it too.